Over the years, the Santa Ynez Band of Chumash Indians has experienced many ongoing battles with local tribal opponents. All too often, these opponents have elevated that opposition to litigation. Such is the case with the local anti-tribal group, Save the Valley LLC, a group that was ostensibly organized specifically to file frivolous lawsuits against the tribe. Fortunately, the tribe has always been on the winning side of these lawsuits, because truth always prevails. Earlier this year, the U.S. District Court denied the request by Save the Valley to intervene in the 1906 case that helped establish the Santa Ynez Indian Reservation. This is the second time in a one-year period that the Federal District Court for the Central District of California has dismissed lawsuits by Save the Valley. Both of the group's federal cases claim that the property where the tribe's Chumash Casino Resort is located is not federal tribal trust land, and that the tribe's expansion project violates local, state, and federal law concerning this land. In other words, they claim that the tribe's reservation is not a reservation. In the lawsuit that was dismissed on July 2, 2015, the court recognized the historical documentation that exists proving the tribe is a tribe. The tribe's land is reservation land, and that reservation land is held in trust by the federal government. In fact, these historical documents were actually attachments to the Save the Valley's own complaint. So while claiming that the tribe is not a reservation, they actually attached documents to their lawsuit that claimed it is. The second case that was dismissed by the federal court on January 8, 2016, was even more absurd. It was an attempt to intervene in the 1906 quiet title action and judgment by the Catholic Church that was part of the settlement agreement that resulted in the establishment of the Santa Ynez Reservation. The Honorable John F. Walter, U.S. District Judge, concluded that the motion to intervene, quote, is not timely because it was filed more than 100 years after the final judgment in 1906, end quote. If Save the Valley wanted to reopen every judgment made more than 100 years ago, it would undermine every land title and threaten every landowner in the Santa Ynez Valley. But Save the Valley only questions issues that pertain to the Santa Ynez Band of Chumash Indians. The tribe has lived with the absurdity of these lawsuits ever since the tribe opened its Chumash Casino Resort more than 20 years ago and has battled against this small group of individuals who publicly belittle and litigate at every turn. Now, others are beginning to take notice. In a January 27, 2016 editorial in the Lompoc Record, readers are reminded just how pointless these lawsuits are. It reads, "Here's the thing about butting your head against a stone wall. It's usually the head that comes out a loser. There's been a lot of head-butting in the Santa Ynez Valley in recent years, as one citizens group or another challenges the Santa Ynez Band of Chumash Indians' authority to operate a successful casino resort and otherwise grow the tribe's business and residential development plans. Think of the Chumash as the solid wall and the opposing neighbors as the headbangers. The end result is inevitable, an immutable law of physics." The editorial goes on to ask the question the tribal leaders and members have been asking for years. When will Valley opponents recognize the tribe's legal rights? And rather than opposing everything the Chumash set out to do, forge a working relationship with the tribe that could work to everyone's benefit? As Tribal Chairman Vincent Armenta recently said, "All we can do is continue to move forward in a positive manner and work diligently to ensure that our tribe continues on our path to economic self-sufficiency."